Welcome, everybody. And thanks so much for staying through this very, very crucial time in our lives, politically, economically, and otherwise. Allow me to introduce myself by firstly telling you a story. Now, most of us who have never had the privilege of meeting our former darling President Nelson Mandela know about him anecdotally, but somebody relating a story. And this story goes as such, that he was walking in a village one day, fresh just after being released from prison, and we know that the interconnectivity is an issue, not only in Africa, but even in South Africa. So there were some people that missed this, and one, either the radio or television, and these two elderly gentlemen had never met facially Nelson, or met him facially. And they proceeded to walk along with him, so, and how's the cattle and the children, we could use more rain, that kind of conversation. At the end of it, when they parted ways, he then went on to introduce himself and said, oh, by the way, I didn't catch your name. I said, no, I'm Nelson Mandela. And they were totally amazed, thinking, wow, this is a man of such enormous stature. He was walking along with us before even assuming that we would know him, or without the grandeur. And the lesson there is that sometimes we are so self-consumed and self-absorbed with our own importance that we forget that ultimately the essence of living and life is to enrich somebody else's, be it monetarily or be it via skills or just making their path a little bit easier on earth. On that note, my name is Cindy Mabi. I co-anchor Sunrise on ETV. Sanbonan. Okay, I'm tasked with being the moderator for this session, and we're going to have two speakers, essentially looking at human rights in corporate South Africa, and also the essence of the judiciary and transformation thereof. Let's try and recover, or even build on yesterday's comments made with regards to transformation and the need for introspection. Is everybody wearing comfortable shoes? Are they square-toed? It's not getting tighter and tighter. Folks, we've come a long way in terms of development, be it creating a safer work environment, a progressive work environment where opportunities are shared amongst many more. But needless to say, much more remains to be done. So on that note, I'd like to call on to the podium Advocate Tseliso Thipanyane, who is the Chief Executive Officer of the South African Human Rights Commission.
Corporate South Africa is complying with human rights. Now, in the spirit of the African culture of storytelling, and also in the much discussions about revolutionaries and counter-revolutionaries and the scorpions, I would like to tell you a short story about two frogs, a revolutionary frog as well as a counter-revolutionary frog. So they were living on an island, and then the island, there was fire on the island, and therefore they had to cross the river. So they meant the scorpions. So this counter-revolutionary scorpions and revolutionary scorpions then decided to get a lift on the back of the two frogs. Now halfway across the river, the counter-revolutionary scorpion then decided to sting the frog. And we all know what happened. And the revolutionary scorpion managed to get to the other side and live happily ever after. Now, in the context of our discussions, you can decide whether business is a counter-revolutionary frog or a revolutionary frog, or you can decide whether the ANC is a counter-revolutionary organization or revolutionary organization. I leave that to yourself. So you can fit anything as to who's the scorpions and who are the frogs. Now, having said so, colleagues, the struggle for democracy waged by our people against colonialism and apartheid was not a struggle for a few to enjoy a good life and lead lavish lifestyles, when millions of our people live under appalling conditions of poor housing, unemployment, abject poverty, and many other challenges. Our struggle was for the transformation of a political, social, and economic order that will ensure a better life for our people. address poverty, and provide equal opportunities for all. And of course, this was actually informed by now the much talked about Freedom Charter, whether people are straying away from it or not. And I won't bore you about the provisions of the Freedom Charter, but they are very interesting ones. For example, that mineral wealth of our country shall be restored to the people, that mineral wealth beneath the soil, banks and monopoly industry shall be transformed to the ownership, transformed and transferred to the ownership of the people, and then all other industries and trade shall be controlled and assist the well-being of the people. That's what we were fighting for many years ago. Now, our constitution does in fact reflect the aspirations and demands of our people that inform their struggles then and continue to do so today. In this regard, the preamble of the Constitution provides for an improvement in the quality of life for all our citizens. And Section 198 of the Constitution, I know many people don't even read this particular section, it provides for a South Africa where its people, as individuals and as a nation, shall live as equals in peace and harmony, free from fear and want, and being able to seek a better life. And the preamble of the Promotion of Equality and Prevention of Unfair Discrimination, the so-called Equality Act, also provides as follows. The transition to a democratic united South Africa, united in its diversity, marked by human relations that are caring, united in diversity, marked by human relations that are caring and compassionate, and guided by the principles of equality, fairness, equity, social progress, justice, human dignity, and freedom. Nevertheless, 14 years into our democracy, our country faces many challenges, especially for millions of our people. Despite many achievements over the years, such as the much talked about economic growth, millions of our people, especially African people, continue to live under abject poverty. The state's own report, as discussed yesterday, towards a 15-year review, while pointing to a 6 to 7% reduction in income poverty amongst African people, acknowledges that African people continue to account for a disproportionate share of poverty. According to this report, while African people made 77% of the total population of this country in 1995 and 79% in 2000, they accounted in both years for 93% of those living on less than 322 rands a month. This, colleagues, is a time bomb waiting to explode. Another worrying development is increasing gap between the rich and the poor over the last 14 years. And again, according to the state's report, the national income inequality, as measured by the Gini coefficient, increased from 0.64 to 0.69 between 1995 and 2005. And sadly, the report says, and continue to do so from 2006 to 2007, which means from 1994, the gap between the rich in this country is increasing, not decreasing. Now, with the exceptions of about 7 countries that have higher Gini coefficients rates, South Africa is one of the most unequal countries in the world. And if this report is correct, we continue to be more unequal. Now, on the impact of economic income inequalities at a global level, David Rothkopf, in his book, The Superclass, The Global Power Elite and the Wealth They're Making, said as follows. The reality is that the combined net worth of the world's richest thousands or so people, the planet's billionaires, and of course people get excited when they see their names in Forbes saying this is now, we have joined the billionaire class, is almost twice that of the poorest 2.5 billion people in the world. The human race may have made great progress over the centuries, but such disparities are an indictment of our civilization, and I believe they are a threat to its stability. Close quote. The income inequality and other forms of inequalities in South Africa manifest themselves along racial and gender lines. In the context of our history and the current global food and financial crisis, these challenges constitute a serious threat to social cohesion and stability of the country, and inform to some extent many of our current political, economic, and social challenges. We're informed that for the last 3 years, every year, there has been over 10,000 service delivery strikes in our country, where South Africans are unhappy about housing and so forth. 10,000 a year. That's serious. Van Pucheru and Colin Bradford, in lamenting similar human rights challenges and their impact, though at a global level, wrote in their book, The Millennium Development Goals, Raising the Resources to Tackle World Poverty. They say, quote, "We live in a divided, polarized world. Half of the 5 billion people living in the developing world live on less than $2 a day. Massive global poverty signifies too many deep failures in the prevailing market-oriented system of global governance. The global economy and policy reform efforts." Secondly, they say economic growth is too slow, income distribution too unequal, and poverty reduction too constrained to generate a sense of progress and hope. The rules of the game and the protection afforded to human rights seem skewed to favor the have over the have-nots. There is increasing frustration, disillusionment, and distrust. As a result, they go on to say the planet is at risk. Even those who are well off feel insecure in a polarized world. Human security has become a widespread global concern of all, rather than a condition affecting only the poor and disadvantaged. Crime, violence, conflict, terrorism, and instability spread unexpectedly into cities and neighborhoods around the world. No one is exempt. Everyone has a stake in changing the dynamics of globalization, which appear to be disadvantaging the global majority. We see what is happening in Nigeria, around the oil area. We see what's happening in Somalia, where people are now serious pirates. We thought pirating was an old phenomenon. Now it's a modern phenomenon. The whole country, or the state, the whole world doesn't seem to be able to deal with this problem. Now, while the state bears the primary responsibility in ensuring a South Africa free from fear and want, and a better life for its people, the current human rights challenges in our country bring into question the role of corporate South Africa as a very powerful and influential component of our society in addressing these challenges and thus strengthening our constitutional democracy. Our constitution makes it patently clear that South African corporations, like other citizens, are equally entitled to the rights, privileges, and benefits of citizenship, and more so, equally subject to the duties and responsibility of citizenship. That's Section 3 of our Constitution. Section 8.2 of the Constitution also provides that South African corporations, as juristic persons, are bound by the provisions of the Bill of Rights of the Constitution, and therefore have a duty to the extent applicable to promote and protect human rights in our country. Several questions could then be asked of corporate South Africa in this regard. Does corporate South Africa sufficiently appreciate its role, and is it adequately contributing to the advancement of human rights in our country? Is corporate South Africa playing the necessary role in the political, social, and economic transformation of our country? And in this regard, what is the role of the black executives? And are they adequately playing this role themselves? Of course, depending on where you are, the answer might be yes, the answer might be no. In any society, ours included, citizens either play a positive or negative role. While some citizens uphold the law, promote positive values of society, and advance its interest, some citizens break the law, ravish other citizens, and plunder their resources. Corporate citizens behave no differently from other citizens. The difference being that due to their power and influence, the impact of that conduct, whether it's positive or negative, is quite tremendous. And we are told of the 100 largest economies in the world today, 51 are corporations. And out of those 51, 47 are in the US. So one can see already there's been a shift in the balance of power from the state to corporations. On the power of corporate entities and their influence, Joe Buchan, I think, is quite radical. He says the following about corporations. Over the last 150 years, the corporation has risen from relative obscurity to become the world's dominant economic institution. Today, corporations govern our lives. They determine what we eat, what we watch, and what we wear, where we work, and what we do. We are inescapably surrounded by the culture, iconography, and ideology. And like the church and the monarchy in other times, they posture as infallible and omnipotent, glorifying themselves in imposing buildings and elaborate displays. Increasingly, corporations dictate the decisions of their supposed overseers in government and control domains of society once firmly embedded within the public sphere. He also says, quite radical, the corporation's legally defined mandate is to pursue relentlessly and without exception its own self-interest, regardless of the often harmful consequences it might cause to others. As a result, I argue that the corporation is a pathological institution, a dangerous possessor of the great power it wields over people and societies. I'm sure Comrade Blade will say viva. Now, in the interest of time, I'll skip quite a lot of things. But having said so, colleagues, of course, like good citizens, you have the bad and the good. And therefore, there are also many other corporate entities who have played a very important role in society. And I don't think I'll get into that, but I have given examples in my paper which will be available to you. Now, it is therefore quite clear that corporate entities do play a dual role in developing and advancing societies and the promotion and protection of human rights, although some will argue that the role is more negative than positive. Now, coming home then, in view of the general impressive economic growth over the past years, the relatively stable political environment in our country, it cannot be disputed that corporate South Africa has played some positive role. However, there are worrying concerns which show a negative side to the role of some components of corporate South Africa, which need to be attended to urgently. These concerns include the ongoing inequalities in our country, characterized by the Gini coefficient, as we've discussed before, challenges around labor issues, especially working conditions many workers are subjected to, including, of course, the issue of safety and health at the workplace, environmental degradation. I was going to say SASO, but I won't say because of the sponsors here. Corruption, again, that's a major issue. And of course, there is a fidentia, there is a red capital, and so forth. And the list is quite long. High levels of crime, and of course, the usual topic, racism and gender discrimination at the workplace, which you are all familiar with. And of course, the slow pace of social and economic transformation of many of our key institutions. And I think people have talked about this yesterday, that there's only 1% stakeholder of black people in the JSC and so forth. Now, these challenges definitely suggest an inadequate attention paid by corporate South Africa in general to human rights and insufficient appreciation of the link between human rights and trade. This is not difficult to understand, of course, colleagues, in view of the role played by corporate South Africa in supporting the oppressive and exploitative apartheid system, and the inability of corporate South Africa to quickly transform in order to fit into the democratic, non-racial, and non-sexist post-apartheid South Africa. Now, of course, one might ask now, if the strength of the apartheid system was the economic aspect, where business played a major role in propping the apartheid system through apartheid laws, exploitation of our people, to what extent has corporate South Africa transformed itself from an apartheid supporter to a supporter of democracy? That's a question mark. 14 years later. However, the unrepresentative nature of corporate South Africa in the context of race and gender and the increasing gap between the rich and the poor are clear indicators of where corporate South Africa is today on the map. Of course, there are good people like yourself in BMFA, but the stats are there. 14 years later, where are we as a country? And what is the role of corporate South Africa as good citizens in actually supporting our democracy and making sure that our country continues to prosper and in an equitable manner and therefore sustainable? Now, the slow pace of transformation in corporate South Africa, an inadequate role in championing the promotion and protection of human rights constitute a threat to the stability of the country and to corporate South Africa itself. In this regard, Benjamin Friedman, in his book, Moral Consequences of Economic Growth, said that experience clearly suggests that the absence of democratic freedoms impedes economic growth, and that the resulting stagnation in turn makes a society even more tolerant and undemocratic. The health of our democracy and the advancement of human rights, which are crucial for sustainable economic growth, should thus be one of the main priorities of corporate South Africa. Now, where we come from, we say human rights are good for business, but sometimes we wonder whether people in the business sector actually appreciate that human rights is good for business. Because without that human rights order, you'll actually not be able to make profits in a sustainable manner down the line. If you check the most successful economies in the world, definitely have a much better record of human rights. There is therefore, colleagues, a pressing need for corporate South Africa to play a far more active role in promoting good governance, democracy, and the advancement of human rights. In this regard, at least you might listen to me now, Lee Iacocca, the former president of the Ford Motor Corporation and Chrysler Corporation, there are very few South Africans who have achieved the status of Lee Iacocca. In his book entitled, Where Have All the Leaders Gone?, said the following about American corporations, which equally applies to South Africa. Instead of living by the deadly sins, corporate America should try living by some of the virtues. Instead of greed, how about generosity? Instead of envy, try a little charity. Instead of pride, show some humility. Instead of wrath, let's see composure. And then he goes to say, our capitalist system holds the promise that every American can succeed. But if we don't infuse it with some human values, it deteriorates into a winner-take-all setup, which doesn't really serve our free enterprise or our common good, close quote. There is therefore a need also, apart from encouraging corporate South Africa to play a much more active role, there's also a need to find more effective ways of regulating the activities of these entities to ensure that their power and influence is not used to undermine the advancement of human rights in our country, but rather play a more positive role in the promotion and protection of human rights. And therefore, there should really be no debate about this. Because as citizens who are governed by law, it is the responsibility of the police and the courts to ensure that we as ordinary citizens behave in a proper manner. So in the same manner, corporate citizens should also be better regulated to ensure that they comply with the laws, the values, and the standards of our country. And of course, this has been one of the weaknesses all over the world, because the view was, do not touch corporate citizens. They are law unto themselves. But clearly, all citizens have to be regulated, and therefore we're saying there is definitely a need for better regulation of corporate society as citizens in order to ensure that actually comply with the law and human rights standards. And of course, what we're seeing out there today clearly shows there has been weaknesses. Otherwise, we would not be facing this global credit crisis today if there was better regulation of our banking industries in the so-called Western world. Now, on the need then for regulation, Joe Perkins in his book says the following: we must insist that corporations become democratic and transparent. No longer will we accept imperialistic capitalism where a few rich men and women take all the decisions and most of the money and do so largely in secret. We will demand that they abide by those principles we hold to be self-evident, as stated in our most sacred documents: principles of justice, equity, compassion, and governance with an eye towards providing peace and stability for future generations. We will recognize, he says, that we live in a tiny global community and that corporations must set new goals that reflects this reality. Rather than accumulating wealth for the few, they must take care of their employees, even after retirement. They must serve their customers. They must look after those who supply the resources they use, who mine, who plant, who pick, who weave, who smelt, who process fashion, and who shape and assemble. They must protect the environment where all these people live. Now, at the UN level, there are also developments to try and ensure that there is a better regulation of corporations, especially transitional corporations. There was a resolution passed in 2005 by the UN Human Rights Commission then to basically look into this thing. And of course, one of the challenges now at the UN level is to identify and clarify standards of corporate responsibility and accountability for transnational corporations and other businesses with regard to human rights. The other one is to elaborate on the role of states in effectively regulating and adjudicating the role of transitional corporations and other enterprises with regard to human rights as well through international corporations. Now, in our own country, we have to strengthen the current regulatory mechanisms, such as the Human Rights Commission, employment equity, and so forth, because clearly there are weaknesses in this regard. And I'll be the first one to confess that the Human Rights Commission itself, over the last 13 years, did not really factor adequately its monitoring role on corporate South Africa. I don't know why, maybe we're focusing too much on the state because we're coming from an era where the state had played such a devastating role on our country, and therefore there was a need to ensure that the state does better. But clearly, corporate South Africa is also very powerful, and therefore we need to do so. The same thing also applies to the employment equity. I've heard Thipanyane complaining about how business responds to him as far as these issues are concerned. And therefore, we really need to strengthen and support these institutions as well. Now, I was saying to colleagues, it's rather strange that the Human Rights Commission with a budget of 60 million a year is required to monitor and keep everyone in check, including corporate South Africa. So that will be a challenge then. Second, we also need to bring into full operation important pieces of legislation, such as the Promotion of Equality and Prevention of Equality Act, number 4 of 2000, and the Promotion of Access to Information Act. I'll tell you why these are important. The Equality Act actually makes it a duty for corporate entities to ensure that there's equality at the workplace. The sad thing about this particular act is that since it was passed in 2000, the section which applies to corporate entities, the promotional sections, have not yet been brought into operation 8 years later. Again, what does it say about political leadership in our country? At the same time, what does it say also about other South Africans? Here is a beautiful piece of legislation which will actually go a long way to help us to address these issues. The Act also requires the Human Rights Commission to submit an annual report to Parliament on the state of racism, gender, and disability across the board, government and private sector. Again, Section 28 has not yet been brought into operation, despite our pleas and pleas to government. Some of my staff are saying that maybe we should actually even sue government and say, listen, bring this act into operation. So again, what has BMF itself done? The other one, of course, is the Promotion of Access to Information Act. I know this one is quite important because I see many corporations actually do ensure that they have manuals and they put them on the website. But what is crucial is not really those manuals. It's the fact that South Africans know this act and can use it to demand information from government as well as from the private sector in fulfillment of their rights. Now, there are very few South Africans who are aware of this act. Secondly, the act allows, just like the Equality Act, for magistrate courts to be courts where people can go and actually demand the information from the private sector, where it affects them, without paying much money, like it is the case with the Equality Court. Now, again, 8 years later, government has not passed the rules board. The rules board of government has not passed the rules which will actually allow magistrate courts to be access to information courts, because at the end of the day, information is vital to democracy. It's also vital to keeping the corporate sector in check. But 8 years later, nothing has happened. Now, in conclusion, Chairperson, so I don't take too much time, it is important, therefore, that corporate South Africa should appreciate that it is a crucial part of South African society, and that the country's problems and challenges are its concerns as well, and that an existence largely in isolation from these challenges is not workable in the long term in our country. I'll skip a few things. Now, in conclusion, this is what Joseph Stiglitz, the winner of the 2000 Nobel Prize for Economics, in his book, Globalization and Its Discontents. And he says the following: what we need are policies for sustainable, equitable, and democratic growth. This is the reason for development. Development is not about helping a few people get rich or creating a handful of pointless, protected industries that only benefit the country's elites. It is not about bringing in Prada and Benetton, Ralph Lauren or Louis Vuitton for the urban rich and leaving the rural poor in their misery. Development is about transforming societies, improving the lives of the poor, enabling everyone to have a chance at success and access to healthcare and education. This sort of development, he says, won't happen if only a few people dictate the policies a country must follow. And I think this has been the challenge in our country over the last 14 years, that to a large extent, only a few have been dictating policies for this country, and we hope that will change. And therefore, colleagues, the challenge for PFMA for BNF and relevant partners like the Human Rights Commission is to ensure that corporate South Africa fully subscribes to our human rights standards and values. Failure to do so carries very high risks for us as a collective. And therefore, in closing, Thomas Friedman, in his book, The World is Flat, says, we need to think more seriously than ever about how we encourage people to focus on productive outcomes that advance and unite civilization, peaceful imaginations that seek to minimize alienation and celebrate interdependence rather than self-sufficiency, inclusion rather than exclusion, openness, opportunity, hope rather than limits, suspicions, and grievance. Now, if you can't listen to me, at least listen to Joseph Stiglitz and Thomas Friedman. I know you read those books. Thank you.
Just touching on some of the comments that you had made, particularly the sensitivity of having to balance industry and also the moral obligation of uplifting as many as possible in the population. I'm also not going to make career-limiting comments because, as Dr. Martin Luther King had said, that when you are right, don't be too radical about it, and when you are wrong, be the first to admit it. If we're sitting amongst industry champions and leaders, and we are saying that in our offices, air-conditioned, and we've got our strategic meetings and the veto vote, and we're highly important, and yet when it comes to issues of transformation, implementation thereof, we are lacking. It's rather a scary thought. I have no problem with acquiring personal wealth and self-actualization and achieving your aspirations and dreams. But what does it all mean if we have, as Dr. Advocate Thipanyane was saying, that on a yearly basis, there's at least 10,000 industrial action strikes that are taking place, purely because people are living beyond the breadline. There's also about 30% of South Africans who are facing food insecurity, just the availability of basic, safe food to consume. And the list is endless in terms of the challenges. So as executives and industry leaders, question is, what are we doing to improve the lives of others, particularly corporate? Because corporate South Africa, I think, starts in the home as well. We are CCs as madams in our homes to our helpers. They may be the auxiliary help, but I mean, if they're not empowered, if you ask the question, does your helper even have a matric, grade 12, depending on which side of the tracks you're from? Do they even have a grade 12? Is your helper paid adequately? Are they able to drive? I mean, those are things that are not necessarily exclusive to the madams and masters. All right, on that note, I'd like to call on our next speaker, Advocate Vuyani Ngalwana, who is the board member of the Gauteng Bar, to talk about the essence of the judiciary transformation. And I'd urge you to please take notes, as we will be discussing or engaging with our panel thereafter.
How many lawyers do we have here? Show of hands. Not many. Okay, good. So, jargon out of the way. I've been requested to address you on the transformation of the judiciary, or rather the essence of the transformation of the judiciary. Some of the things I'm going to say here are going to result in me having very few friends, on both sides of the tracks, black and white. But I don't care. And many of you will be surprised what the policy, as I understand it, of the African National Congress seems to be on the transformation of the judiciary. It seems to me it has little to do with race. But let's get on with it. There are 199 permanent judges in South Africa. 78 of these are white men. 13 of them are white women. So white judges comprise just under 46% of the South African judiciary. 59 judges are African males. 15 are African women. So just over 37% of our judiciary comprises African persons. There are 12 colored males and 4 colored women. There are 10 Indian men and 8 Indian women. Now, in the tradition of black consciousness, which is my background, I shall refer during the course of my address to black people will include colored persons and Indian persons. And if I want to refer to people who have my hair texture, I shall refer to us as Africans. So, black judges, in the manner in which I've just described, comprise 54%, over 54% of the judiciary. Women of all races comprise 20%. Now this is down from June last year, which was 30%. From this small fact, it appears that the transformation of the judiciary to reflect gender demographics is regressive. But that is not the main thrust of my address. The Judicial Service Commission, which interviews and recommends judges to the President, set from this past Monday to interview candidates for judicial office. I think they finished today. One Constitutional Court judge is due to retire at the end of this year. is an African man. There are 6 candidates who have put themselves up to take his place. 3 of them are white men. There would have been 4, but the 4th white man, it seems to me, was persuaded to withdraw his candidacy by a lobby group in order to accommodate another white man who, by all accounts, seems tipped to get the nod, at least from the Judicial Service Commission. Our president will then have to decide whether the replacement of an African-made constitutional judge by a white man is desirable in light of the legislative framework intended to transform South African society in all its manifestations. On Monday, we heard that an African candidate for the Constitutional Court has also withdrawn his candidacy. Tuesday, yet another withdrew. Naturally, no reason was given for these withdrawals. Now on ETV, commentators propound the line that these are casualties of the Constitutional Court complaint against the Cape Judge President. I find that laughable if it were not vacuous. This, of course, leaves the door wide open for the white men preferred by the lobby group to get the nod, because all credible competitors for the position have, in my view, been persuaded by this lobby group to stand aside and apply perhaps next year when 4 vacancies arise in the Constitutional Court. This latest development convinces me more than ever that this lobby group's candidate will be appointed to the Constitutional Court unless our new president considers the matter very carefully by applying the criteria upon which the African National Congress resolved in Bulukwane last year. I shall come to that because that is the main theme of my address, that particular resolution. In my respectful view, if one considers at least one of this judge's most recent judgments, he does not meet the criteria, and it would be wrong and a terrible mistake to appoint him at this stage to the Constitutional Court. In September next year, 4 more judges of the Constitutional Court are due to retire. 2 of them are black, including the country's Chief Justice. The other 2 are white, a woman and a man. Again, when the Judicial Services Commission recommends names to the President next October or November, the challenge for our new President will be to consider the desirability of replacing black Constitutional Court judges with white persons. Leadership of the judiciary, at least on the face of it, is firmly in African hands. Our Chief Justice is African. His deputy is African. The President of the Supreme Court of Appeal, which is the second highest court, is African. All 9 judges president, that is the heads of courts, of the high courts, are African. Except, of course, for the Western Cape, where the acting head of court there is a white woman. Surprise, surprise. These are the numbers. These are the facts. In my view, hardly. The ruling party's view on this matter is rather revealing if we cannot, and of course we can't ignore it. Since it came into power in 1994, the ANC adopted a resolution, or not once has the ANC adopted a resolution that says that judicial transformation involves racial composition of the judiciary. So when a judge of the Supreme Court of Appeal publicly criticizes government policy of appointing what she terms unskilled and inexperienced black judges over what she calls worthy white judges, I wonder where she gets her information from. On the subject of judicial transformation, the ANC, it seems to me, has rather tended to focus on accessibility of the courts through both geographic proximity to the people whom these courts are supposed to serve, the use of all official languages in the courts to facilitate accessibility to justice, the restructuring or rationalization of the court system to take on board community courts and traditional courts. Let's trace briefly what the ANC seems to have in mind by transformation of the judiciary. If the resolutions taken at its national conferences since 1994 are any indication, then to the ANC, race does not seem to have anything to do with judicial transformation. This should really come as no surprise, in my view, given the broad nature of the church that is the ANC. Its membership comprises all colors of what Archbishop Emeritus Mbilo Tutu called the Rainbow Nation. And so one wouldn't want to offend members of the broad church. And I'm not being sarcastic, really. At the Bloemfontein National Conference in December 1994, the focus as regards transformation of the judiciary was on the establishment of an independent and representative prosecuting authority, including the possibility of setting up a central office of the Attorney General. Now we have the National Directorate of Public Prosecutions. And the restructuring of the courts to take on board issues of community courts, traditional courts, and mechanisms to ensure accessibility. An African man was then appointed in July 1998 to lead the prosecuting authority, and he was succeeded by yet another African man. No resolution was taken at the Bloemfontein Conference to the effect that judicial transformation entails a wholesale appointment of black or African judges. Trace them step by step. And I'm focusing on national conferences because that is the highest decision-making body of the ANC, as I understand it. I'm not a member of the ANC. I go by what their policy documents say. Now, no such resolution was taken at the Mafeking National Conference in December of 1997 either. At that conference, the ANC's focus was on the rationalization of the magistracy and judiciary into a single judiciary. The rationalization of the court system to provide at least for a high court in each province, which is to be situated in the capital of such province. The establishment of specialized family courts to adjudicate on and deal with family-related matters. The establishment of community courts, the provision of a training program for judicial officers intended to sensitize the judiciary to constitutional imperatives, and to set up a grievance procedure and mechanisms for complaints against judicial officers. That was the focus of the 1997 conference on judicial transformation. Not once was there a resolution taken that we should pack the courts with African or black judges. At the Stellenbosch National Conference in December 2002, the focus was on speeding up legislation to create a grievance procedure to deal with complaints against judicial officers, expediting the transformation of the judiciary by creating a more representative, competent, sensitive, and humane and responsive judiciary, prioritizing crimes against women and children, especially rape, and strengthening the victim empowerment system. I'm not sure what was meant by creating a more representative judiciary. Was the intention to create a racially representative judiciary? That's a possibility, if one considers the number of black judges today in comparison to 1994. Was the intention to create a gender representative judiciary? Again, that is a possibility if one compares the number of women judges as compared to 1994. And of course, the former president's penchant for women empowerment. Now, the judge of the Supreme Court of Appeal, who now lambasts government for a non-existent policy, forgets that she herself is the beneficiary of the government's empowerment of women. In my view, there is another possibility. And here's the crux. And that's philosophical inclination. If I were in government and intent on transforming the judiciary, I would focus less on race and gender and more on the philosophical makeup of each candidate. And I shall return to this proposition very soon. Last December in Polokwane, no less than 15 resolutions were taken in relation to the transformation of the judiciary. None of them proposed that judicial transformation entails swelling the ranks of the higher courts with black or African judges. I'll leave you to go to perhaps the African National Congress's website to familiarize yourself with those 15. I'll just touch on a few. One was that the Constitutional Court would be the highest court in all matters, whether constitutional or non-constitutional. The other was that the Labour Appeal Court would be integrated in the Supreme Court of Appeal, that the outdated court descriptors would be renamed. You've got the Transvaal Provincial Division, would probably change to, I don't know, the Tshwane High Court or the Pretoria High Court. You still have the Bophuthatswana High Court, you have the Ciskei High Court, you have the Transkei High Court. The other is that regional courts to deal with civil matters would be established. As lawyers know that the regional courts deal only with criminal matters, as far as I know. I don't appear in the regional courts and magistrates courts, so I wouldn't know. I'm still operating from memory. It may be a tad flawed, so you'll correct me if I'm wrong. And the other is that every person must enjoy the right to use an official language of his or her choice in all court proceedings of first instance. And here is the most important, in my view. Appropriate mechanisms. In fact, let me just go there. The resolution read as follows. Appropriate mechanisms must be urgently established to pursue priority or to pursue the priority of establishing an adequate pool of judicial officers who are steeped in and reflect the progressive values of our Constitution. Let me say that again. Appropriate mechanisms must be urgently established to pursue the priority of establishing an adequate pool of judicial officers who are steeped in and reflect the progressive values of our Constitution. That was the resolution. In my view, this is the single most important resolution the ANC has taken in relation to the transformation of the judiciary in the past 15 years. In other words, since it came into power. Well, 14 years and give or take a few months. The resolution captures, in my view, the essence of judicial transformation. It is the benchmark against which all judicial appointments must be measured. Not the blackness of your skin, not the whiteness and experience, 60 years on the bench, none of that. But what are, cynics will ask, these progressive values of our Constitution? Is it what the government says they are? No. The answer lies ineluctably in our national Constitution. The progressive values of our Constitution are three in number, in my view. They are human dignity, equality, and freedom. Human dignity, freedom, equality. Equality, freedom, human dignity. In whatever sequence you mention them, those are the values that are foundational to the Constitution, the Bill of Rights. The country called South Africa is founded on those three fundamental values. It's not me who says this, it's the Constitution, and I'll prove to you in a moment. So these values are not what politicians say they are from time to time, which may change according to the agenda sought to be achieved at a given time. They are constant. For example, Section 1 of the Constitution says that South Africa is founded on human dignity, the achievement of equality, and the advancement of human rights and freedoms. These three constitutional values are the foundation of the Bill of Rights chapter in our national constitution in terms of Section 7. Sorry, this sounds like a lecture, but this is very important. Maybe when you have time, you can visit the Constitution and read it for yourself. They are also the measure by which the reasonableness and justifiability of the limitations of other rights in the Bill of Rights chapter must be gauged. In other words, in order to determine whether or not the limitation of, say, freedom of expression or freedom of movement and residence is reasonable and justifiable, a judge must have regard to the effect that such limitation has on human dignity, equality, and freedom. In this regard, Section 36 says so pointedly, and I'll quote, it's very short. It says, "The rights in the Bill of Rights may be limited only in terms of a law of general application to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom." What is more, these three values are also the central feature in the interpretation of the Bill of Rights in Section 39(1). It reads as follows, and it's also short. When interpreting the Bill of Rights, a court, tribunal, or forum must promote the values that underlie an open and democratic society based on human dignity, equality, and freedom. So these three values are not only fundamental rights under the Bill of Rights in themselves. They are also the values on which the country called South Africa is founded. And they are the essence with regard to which the Bill of Rights chapter must be interpreted. In short, folks, without human dignity, without equality, without freedom, there is no country, there is no Bill of Rights. It's as simple as that. That is how important these three values are. Now, these values, which the ANC says all judicial officers must be steeped in, are not the sole preserve of any one racial or gender group. I'm not aware of any empirical evidence that a black or African judge is more likely to espouse and apply these values than a white judge. That is not what I understand the ANC to be saying by this resolution. In fact, if one considers the things done by the Constitutional Court, which is 72% black, one finds that these things are not, in my view, consistent with these values, the things that they have done. I could give you examples, but since I'm counsel in a matter involving Constitutional Court judges, I consider it more prudent to say less about the matter. But when the case is finalized, I think there are things that need to be said, and I shall say them in an appropriate forum at an appropriate time. The simple point I make here is that the progressive judge who is steeped in and reflects constitutional values is not necessarily black or African. Such a judge is not necessarily white either. There is no empirical evidence that a white judge is better equipped to apply the constitutional values than a black or African judge. In fact, in October last year, the Supreme Court of Appeal, which is 60% white, issued a ruling that where an employee has been found guilty of misconduct, the determination of a sanction is the sole preserve of the employer, and that the CCMA cannot interfere with the employer's decision. So if the employer were to decide to fire the employee, the only thing that the employee can challenge in the CCMA is whether or not the conduct of the employee is indeed misconduct. But it cannot second-guess the employer's decision in firing the employee. Now, equality includes the equal protection and benefit of the law. And equality is one of the values on which South Africa is founded. If only the employer has a say as regards whether or not an employee must be fired under the guise of this reasonable employer test, then how on earth can an employee enjoy equal protection of the law when he cannot challenge the employer's decision to fire him at the CCMA without reference to what is called this reasonable employer test? But thankfully, the Constitutional Court corrected that mistake and said the reasonable employer test doesn't form part of the law, of our law. It never did. Now, before that, the Supreme Court of Appeal attributed to the trial court the phrase generally corrupt relationship. Now, before I get to that decision of the reasonable employer test was actually handed down or was authored by this very judge, white male, who is being pushed by a lobby group to sit on the Constitutional Court. Now, if all indications are true, it appears that he is headed for the Constitutional Court, and no one is going to change that, except for the President. Now, before that reasonable employer test judgment, the Supreme Court of Appeal attributed to the trial court the phrase generally corrupt relationship to describe a relationship between Mr. Shabir Sheikh and the President of the ANC. It later emerged that the trial court judge apparently never made such a remark in his judgment. The way, though, had been paved on wrong facts by the Supreme Court of Appeal, which is majority white, that the president of the ANC is corrupt. This was an affront on his human dignity. And human dignity is one of the values on which our Constitution is founded. This demonstrates that a white judge or a group of white judges is not necessarily better equipped than a black or African judge to reflect progressive values of our Constitution. So, and I don't want to be understood that I'm attacking white judges. I am not, because I've also said that black judges and African judges are not necessarily better equipped because of their blackness to reflect the progressive values of the Constitution. And I gave as an example the Constitutional Court's conduct in the past couple of months. So please don't misquote me if you want to quote me. So if racial considerations are either inadequate or irrelevant for the establishment of an adequate pool of judicial officers who are steeped in and reflect the progressive values of our Constitution, then how on earth does the ANC hope to achieve this without being accused of packing the judiciary with people considered to be sympathetic to it? The answer lies in the appropriate mechanisms that the ANC established or establishes in pursuit of that very important goal. You'll recall that in their resolution, they talked about appropriate mechanisms being put in place to achieve this result. I don't know whether these mechanisms have been established yet, and I'd love to take a look at them. If there's an ANC person who has access to these things, I'd love to see them. And I'm not the only person. I'm sure there's a pool of other people who'd like to see them. And there are a few people who'd like to assist, really, in the transformation of the judiciary. Maybe we can offer our 2 pence worth. In my view, it is relatively easier to gauge the progressiveness of candidates coming up for judicial appointment to the Constitutional Court, the Supreme Court of Appeal, and the High Court, where those candidates have previously acted as judges or held judicial office in the lower courts. From their written judgments, one can determine whether or not and the extent to which they are steeped in and reflect those fundamental values. The difficulty arises where the candidates are academics or attorneys and advocates who have never acted as judges before. I am from the school that believes that such people should never be considered for appointment to the judicial office without a reasonable number of acting appointments under their belts, and a reasonable number of reported judgments too, so that one can gauge from a perusal and study of those judgments whether they are suitable on the basis of the resolution taken by the ruling party. A clever academic does not a judge make, in my experience. Instead, you tend to get long judgments with elusive rationes or elusive reasons for the judgment. In conclusion, the essence of judicial transformation lies not in packing the courts with black judges. It lies not in packing the courts with women judges. It lies not in packing the courts with white judges. It lies rather in packing the courts with judges who are genuinely beholden to the Constitution and the fundamental values thereof. It seems to me that the Supreme Court of Appeal judge who publicly lambasts government for doing that for which the Constitution makes provision is clearly not beholden to the Constitution to which she has sworn allegiance. Since 1994, the former presidents have made mistakes in some of their judicial appointments. Now, if they want to know who those judges are, they can call me, I'll tell them. It is my sincere hope that the appropriate mechanisms of which the ANC speaks in its 2007 resolution, with a view to establishing a pool of progressive judges steeped in and reflective of the values of our Constitution, is adopted soon, if it hasn't been adopted yet. When appointing a candidate recommended by the JSC, the President must always bear this in mind. And I hope this analogy is not misinterpreted. I don't mean to be rude to women. I mean, I've never given birth, so I don't know what happens there. So let me say this again. When appointing a candidate recommended by the Judicial Services Commission to the President, in my view, will do well to consider this, that they are appointing a judge is like giving birth. Once done, it cannot be undone. It is considerably more serious than a matter of labor relations, and no pun intended there. And so it is also considerably more difficult to do, to remove a judge once you have appointed. So if you make a mistake in appointing a judge who does not reflect the progressive values of the Constitution, but simply says he or she does, you are stuck with him until he reaches retirement age. Who knows, the lobbying group may even prevail on our President to extend the retirement age of judges from 72 to 80, thereby ensuring that their man or woman and their insalubrious ideas are irreversibly entrenched in the nation's legal framework. In my view, that is the threat to our democracy. I say the genuine transformation of our judiciary must begin with the candidates now sitting for interviews before the Judicial Service Commission. This nation cannot afford to miss the opportunity to transform the judiciary for good. The Constitutional Court and the Supreme Court of Appeal are, in my view, particularly crucial in this regard because they have the final say in matters before them. The Constitutional Court in respect of constitutional matters, and hopefully, and I pray to God that the Constitutional Court does not become the apex court, because when that happens, God help us. Enkosi bethu.
Folks, we don't really have a lot of time. I think we have about 30 minutes. There's a lot that we have observed. And I know you may be expecting a response about an ETV comment a little bit earlier. I am not going to appoint myself Golding. I don't have the shareholdership that he does, so I'm not going to respond to that one conveniently. And I love the maze and the thought process that you have taken us on, Advocate. It's been an education in how you went from one point to the other, but let's just dissect or interrogate some of the issues that you'd like to know. One, about whether corporate South Africa are doing enough to promote and protect human rights, and secondly, just looking at the independence and the judiciary in the country. We'll open the floor to the delegates. I would like to hear what your thoughts are.
Thanks. My view is that I think clearly the transformation of the judiciary is very important. I won't really talk about judges. I think it's said enough. My concern as a lawyer is that, if you look at in private practice, especially in Johannesburg, especially amongst advocates, how many black advocates are there, and what kind of support they get from government. There's been a major challenge in that regard. Secondly, the issue of access to justice. There are very few South Africans who can actually afford legal services. There They're very expensive. Some of them will charge about 10 grand a day. Now, how many millions of South Africans are denied their right to access courts in order to have their disputes resolved? This is why then our people take to the streets. And I think personally, government has done very poorly in transforming the judiciary, including the legal profession. And sometimes one even wonders whether they actually vested interest to ensure that this very important and crucial sector of our country is not transformed. How many white law firms in this country? How many black law graduates are able to get articled clerks to actually be attorneys? How many black lawyers who want to become advocates have the resources to go to the bar and spend, is it a year now, doing privilege, and afterwards getting briefs? And as a result, we have a whole lot of people in our country who are able and competent to get into the profession, and are being denied that due to lack of economic transformation, as well as the lack of transformation in the judiciary. And therefore, I think the two are wrong, because the appointment of the judges, while it's very important, also depends on the quality and availability of lawyers we have. And if we don't address that, then that's why people are saying, well, you don't have enough black judges, or you appoint incompetent judges, black judges, simply because there isn't a sufficient pool. And at the same time, how many black law graduates in this country are unemployed today? The last time I checked, there was more than 300 LLB graduates with no jobs in this country. Thank you.
African Ngalwana, I'm not sure if you'll answer as we go along, or would you rather, let's take about another 2 questions. There's one at the back that I noted. We'll take 2 more and answer those in sessions.
Advocate Thipanyane, I'm asking this question as a matter of national interest or public interest. In other words, the question will be digressing from your brief. The question goes, if an ordinary member of public were to utter words perceived to be alarmist, racial, or threatening, and your Section 9 institution is approached, then this particular individual comes to you and say that I will explain the context under which these words were uttered. Would you treat this ordinary member of public the same way as you did to Zwelin Zimbabwe and Julius Malema? And tied to that question, you have to answer in national interest. What positive measures, if any, are you making or taking to redeem the image of your battered, fractured, or compromised organization in the eyes of the public?
All right, thanks. Just one last one, and then I'll allow our panel to respond. That's fine, we'll take them in sections. Let's just allow them to respond, and then we'll continue with the other questions. Just for now, the final question at the back there.
Okay, my name is Tseliso, and my question will go to Advocate Thipanyane. Now, say you broke it down very nicely for us, and the question is also for social interest. You gave us a breakdown of the population of Africans living under the $2 a day situation. Now, of that, could you just kindly, I don't know whether you have the information or not, but could you also break down what the percentage is of whites in South Africa living under the very same conditions? Do you have that information, or is that information not available?
All right, while I understand that statistics are quite useful, it's often good to know what the data is going to be used for. Safe to say, I'm not wanting to answer on behalf of the Human Rights Commission, is that the large majority of poor South Africans would be black. And we know that in recent years, we've seen a number of low-income earning, if not poor whites. Now that we have that information, sir, what's the point?
I ask because now a debate was raised in the company that I work with where, companies are now supposed to toe the line with regards to affirmative action. And white counterparts were very adamant that they were also now on the receiving end. Now, the question I'm posing onto the floor is that these are people who are, or should I say, were advantaged previously. Now, how many of them can we say are in the situation that a majority of the black nation is in? I don't know whether maybe that clarifies it or not.
All right, just to our panel, and we'll continue with other questions as I mentioned. Can I just go to Advocate Thipanyane? All right, just to our panel, it was fun. And we'll continue with other questions as I mentioned. Can I just go to Advocate Thipanyane? I think there were a few posed to you, the fairness in front of the law, or at least the way you treat certain political figures and utterances made is the same extended to Joe the plumber and the $2 per day question.
Thank you. Good questions, all of them. Let me start with the last one. We got the stats from the 10-year, what is it called? Towards 15-year review. And the question you're asking for actually is in the report. They actually, I forgot my paper there, but actually give you the table. But even 93% of the so-called pro-African, then you can imagine then who fills in the rest. That's 7%. And of course, the next group will be colored people, and then Indian people, and then white people. The percentage really of poor white people who fall under this rate is quite low, actually, less than, I think, 2%. So you can imagine that. That's why people are really raising this concern that, we need to do something. The same thing also apply to affirmative action. Again, if you were to look at the percentage of unemployment within the three groups. Again, African people still occupy a very, very high percentage. At the 25% unemployment rate, if you were to look at unemployment rates in developed countries, probably talk about 4 or 5. And we need to be very clear that, if you were to have the same kind of unemployment rates we have in this country, in Western countries, there will be riots. Okay. Now, as I'm saying, we're still sitting on a time bomb here. So for me, and I'm glad yesterday we were told that there is no way we're going to reverse affirmative action. In any case, it's enshrined in our constitution. You'll have to amend the constitution to remove the clause, section 9, 1 and 2, on affirmative action. Because it says it's about ensuring, addressing the effects of disadvantage. So as long as there are people in our country who are disadvantaged, you will need affirmative action. Of course, we're not blind to the fact that there's also an increasing number of white people who are being unemployed and who are also poor. But we need to balance these things in a proper manner and also in its historical context. And also, of course, how we implement affirmative action is also very important. Affirmative action does not simply mean, therefore, putting people who can do the job simply because they are black. I think it's also the point which my brother was also talking about transformation in the judiciary. Now, on the issue of Malema and Vavi, very interesting. I hope I won't take too long here. Certainly, let me not get there. Let me just put it like this. We get 10,000 complaints a year from South Africans on human rights violations. And we only take out of that 10,000, 30 to court. 30. The last time we took someone to court was actually last month, where a white magistrate called a cleaner a baboon after the cleaner banged the court's door and scratched the door. You can imagine. And we'll be appearing in court on the 11th of November to basically asking for damages, maybe 150,000 rand. It depends what the court will do. Now, clearly, and the last time we also took a white person who called his maid Kafa maid. Actually, he sent an SMS to his wife saying, "Where's a Kafa maid?" Unfortunately, he made a mistake. He pressed the wrong button, and the SMS went to the maid, and therefore and then of course we took the person to court, and then he was fined 10,000 rands by the magistrate court. Now, we need to view the work of the commission in the context of nation building. And therefore our act actually says we must try as much as possible to mediate and reconcile South Africans. We're not a court of law. We don't even make binding decisions. We only recommend. And it's up to South Africans to listen or not to listen. So we try and resolve many of the complaints we get, 10,000, and last year it was 11, the year before it was 12,000, in a peaceful manner to bring peace. Section 198, harmonious existence between South Africans. That is our driving agenda. It's only where people really give us an attitude that we actually go to court. Okay? Now, Mr. Vavi and Malema, of course the remarks they made were completely unfortunate. And of course the ANC itself, through the Deputy President and the SG, said the remarks were reckless. Okay? Now the challenge for us was this. Even before we could get to Mr. Malema issued a press statement saying he did not mean what he said. And it should not be taken literally for what he said. Okay? But we still felt that the remarks were a serious threat to our constitutional democracy. And therefore we asked him to retract. And by the way, I need to set this for the record. We never, in writing, asked Mr. Malema or Mr. Vavi to apologize. That was a construction of the media which led the whole country to say, we want to hear him saying, "I am sorry." We never said that, in writing. But unfortunately, we ourselves found ourselves in this mess now, where South Africans want nothing else. They said, "You said Mr. Malema must say sorry, and he didn't say sorry, and therefore you are battered, you are useless, you are irrelevant." That's fine. Now, with Mr. Malema, we spent 2 hours in Lutuli House because the ANC then wrote to us saying, no, you cannot deal with Mr. Malema directly. He's a member of the NDC. So we will set aside a committee of 8 people to resolve the issue of Mr. Malema. So we went there, 2 of us, and said, colleagues, we hear what Mr. Malema says. Even I myself use the words, "I'll kill you" in the commission. From a suit, I will lie. Okay? But I know I cannot stand in public and say, "I will kill you." Even though, of course, I don't mean to kill you literally. That's fine. So this was a case of the NCNs. So listen, Mr. Malema said it. He said, "Oh, we understand that. But now what about Chinese? What about the Portuguese who might not understand that Mr. Malema was speaking Sepedi and not in English? How do you address that situation?" So the ANC then wrote us a letter saying, "No, we must withdraw our ultimatum on Mr. Malema." We wrote back, said, "We will not withdraw the ultimatum. Mr. Malema must stand up and reassure South Africans that he does not undermine the Constitution and retract, otherwise we go to court." Guess what happened? Winnie Mandela, without our invitation, brought Mr. Malema to the Human Rights Commission. Okay? Kicking and screaming. Because Mr. Malema had said he will not come to the Human Rights Commission. That's what he said. You all know that. So he came there and we had a discussion for 1.5 hours. And ultimately, Mr. Malema agreed to sign a statement, which goes like this. 1, he regrets the words he made. He accepts the criticisms for his words. And therefore, he's calling upon all South Africans. And secondly, he said he will never use the words "shoot to kill" again in public in his life. Thirdly, he said he upholds and respects the Constitution. Fourthly, he calls upon all South Africans to conduct themselves in a manner in line with the Constitution. And he signs. Now, I'm expected to say, hey, where is the story? Then I say in Sesotho, if motu are utlwile, ngase piti. That's an apology, colleagues. Mr. Vavi clearly made the statements intentionally. And for him, we said, you, unlike young Mr. Malema, you are going down. There is no way. You are going down. Guess what happened after calling us yesterday commission? We can go and hang publicly, joined by Dr. Blakesman saying we're kangaroo court. Mr. Vavi came to the commission. He wrote to us a letter which was not publicized to the public, saying, colleagues, I have great respect for the work of the Human Rights Commission. And I support this commission. And therefore, this is a minor matter which we can resolve amicably. We said, fine, Mr. Vavi. Mr. Vavi came there with a delegation of 5 or 6 people for 5 hours. We're haggling with a 15-page type paper which he read. We had to listen to him reading the paper, 15 pages typed. And afterwards he says, colleagues, I want to say this. I regret having, he says, I regret having the words used, words shoot to kill, and I think they were too strong. Full stop. Then we say, sign. He then signs. Now, Ms. Porter from the DA comes to the Human Rights Commission and says, yeah, you guys, you are scared of the fight. I said, Ms. Porter, if a man says, I regret for having used the words, why should I take him to court as a South African? Where is Ubuntu?
All right, the gentleman with the program up there. Maybe I should just... I hope that answers your question. Tala noted, the gentleman with the mic now, and I'm going to try and be as fair as possible. Okay, gentleman there, and then Uputilo with the brown shirt, and then the lady in front. Let me just mark 5. And then the 2 at the back, on this side for now. All right? Okay, carry on. Please introduce yourself, sir.
My name is Muhao from Bombela in Nelspruit. I just want to ask, the face of the most successful lawyers or advocates in South Africa is white. Even our top business leaders who are black are using white. Even, I won't go that far, use the white advocate. Why aren't we seeing successful and really exceptional advocates conducting the matters of the people at large, generally?
All right, Kwasitelo Puti with the brown shirt, just second row there, thanks.
Thank you. Advocate Vuyani, if I had my way, I could have asked you to talk the whole day, and you may not know that I've read most of your judgment when you were the pension adjudicator, and I think you are brilliant,
Yes.
Especially protecting the poorest of the poor in society against the mighty corporate. But help me here. I just want to know your opinion about. There's so much that's been said about the Nicholson judgment being controversial. I just want to declare it without criticizing the judge, but just to put it clearly for us, so that we understand. But then there's another one where I find myself helpless, and a number of people, is where this judicial appointment, if all these lobby groups and other people, lobby groups and the powerful people have made mistake, and the president will endorse that, where do we now feature as the weakest in the society, to stop that kind of, what I'll call miscarriage of justice. Thank you.
Thank you. Tseliso with the thanks.
Thank you. My question is to the CEO of Human Rights. Not only in the national interest, but also in the interest of women and children's rights that we have seen heavily violated during the period, that is, during the last 14 years. If I heard you correctly, you said that you are faced with challenges with regard to the implementation of the equality policy of 2000. Some of those barriers are from the government, like, for instance, the framework hasn't been completed, that is, with particular regards to regulations. I would like to know from you, during the last 8 years, because you kept on saying nothing has been done during the last 8 years, as to what the Commission, in terms of now dealing with the challenges, what the Commission has done, and also whether, rather than asking organizations or institutions like BMF, whether the corporate is compliant or not, to use those groups as lobby groups in order to get the government to do its job. Thank you very much.
And may I just humbly appeal, because we're racing against the clock, to keep our questions short and sharp to give as many people an opportunity.
My question is to Advocate Ngalwana. Advocate Ngalwana, I noted in your comments, you only talk about the judges when you're referring to the judiciary and the transformation thereof. I'm concerned that, in my experience, most of the people who actually come into contact with the legal process, they do that with the magistrates. And I don't hear a lot being spoken about the transformation of the judiciary and the magistrates court. I understand your shortcomings because you are an advocate, so you don't deal with those things.
All right, I'll just ask the advocate. I think we've given Vuyani enough time. If you'll just respond to those.
Mandiqale ngale yakho i-question. Mandiqale ngalo wakho umbuzo. You're quite right. I did consider this when I was reading this 15-year review of our democracy issued by the presidency this past week or earlier this month, of also focusing on the magistracy. My paper would have been 4 times as long as it is now if I had done that. That's the one reason. The other reason, of course, was I wanted to focus on the higher courts, particularly the Supreme Court of Appeal and the Constitutional Court, simply because the legal buck really stops with them, and it's very important to have right-thinking people at those levels. Because even judgments that come from the magistrates court, eventually in the appeal process will end up either in the Supreme Court of Appeal or in the Constitutional Court. And so my thinking was it's imperative that I focus there. I'm not suggesting at all in my address that the magistrates do not form part of the judiciary, no, far from it at all. I just simply for expediency, for the sake of expediency, focused on the judges of the higher courts. And it's not because I don't practice in the magistrates court. You're right. It's not because I'm an advocate that I don't practice in the magistrates court. It's just simply the nature of my practice. But that's not the reason I didn't deal with magistrates. I trust I've dealt with the question. If you're not satisfied with it, then you're free to have a rejoinder. As regards the third of the first set of questions, there was something about miscarriage of justice. I must confess I didn't quite get the question, but it seems there was talk of miscarriage of justice and the appointment of wrong people. If that was the essence of the question, and I think there was a question as regards what is it that we ordinary people can do to avert that. I don't know if I understood you correctly. Well, I suppose the thing that we ordinary people can do is, given the electoral system in South Africa, one would have to join the ANC. I'm not recruiting. One would have to join the ANC and raise these issues in the structures of the ANC. And then hopefully they'll be dealt with at the highest level by the president when he then, or she as the case may be, considers the recommendations made by the Judicial Service Commission. This, of course, doesn't have to be only dealt with at the presidential level, because there's also the Judicial Service Commission. In my view, there's another controversial thing coming from some people. I think there may be a need to relook at the constitution of, not constitution as in the four corners of a document, but the manner in which the Judicial Service Commission is constituted. I think there could be some improvement there. I think I've said enough controversial things. As regards the second question, the Nicholson judgment, to put it clearly for us lay people, look, I would be cautious and not want to get too. I've read the judgment, but I wouldn't want to go too deeply into the judgment, in as much as it's on appeal and involves a former president who's brought in I don't know what to call it, whether it's an application or an appeal application, when he was not party to the court and so on. It's quite confusing. But I'm sure he's received legal counsel and what he's doing he thinks is the right thing. But suffice to say this, I don't think Judge Nicholson was wrong in doing what he did. Because the way I read it, the counsel for the state, or is it the NDPP, brought an application to have certain material struck out. Now, a judge would have to deal with that to consider whether or not the material is indeed material that's, that should be struck out. And in dealing with that material, one has to look at the veracity of the factual averments made in that regard. And of course, he can draw inferences from, there is a legal principle, for example, that says, if information is in the possession of a party to a litigation, and that party is not forthcoming with that information, and the other party speculates, then the judge can draw inferences from the speculation. Because it's not the judge's fault that the party who has the information doesn't come out with it to dispute what the other party is saying. And this is an old principle. I mean, it dates to 1910 or something. It's an old judgment. So that's as far as I'm afraid prepared to say about the Nicholson judgment. It's simply to say this, that I don't think Nicholson was wrong in what he did. As regards the first question, why are there no successful black counsel conducting cases of prominent black people and so on? Look, it's a choice that a person has, which counsel he or she wishes to use. There are many successful and very competent black counsel. In fact, the black counsel with whom I keep company, they are very competent. And I hope that it rubs off on me, from time to time. And I cannot answer the question why they are not being used. Perhaps it's a perceptual thing with the media, and some people, I'm not saying all the media, I mean there are some people who are not in the media, who perhaps form part of this lobby group I keep referring to, who seems to thrive on ravishing black professionals. Maybe there's something they gain out of it, I don't know. So a short answer to your question is it's a choice that a person makes. Maybe it's a perceptual thing that a white counsel is better than the black counsel, which is a fallacy. There's no such thing. That's that.
All right. There are a few long notes that I'll read as well if we're out of time. But can I just give Thipanyane a chance to respond to the failure seemingly from the HRC in the protection of women and children's rights?
First of all, I want to start by saying that as a former natural scientist, I hold a BSc in biology chemistry. Your blackness can never determine your intelligence. It's one of the most stupid things I've ever come across, to assume that because I'm black, I'm daft. And we need to set the record straight. Now, on the rights of the child. Now government owes about 3 reports to the UN on what it has done in advancing children's rights. The Equality Act provides for an amendment of the Act to include socioeconomic grounds as grounds of discrimination, which means if you discriminate against a poor person because of his or her socioeconomic status, it is therefore deemed to be unfair discrimination. And those who are discriminating must then prove to the courts why they should actually not be found in violation. Now, government 8 years later has yet to amend this act. Now, we were commissioned by government, Justice Department, they gave us money to advise them, and we advised them, and we're still waiting. Now, we have gone to Parliament to raise many of these issues about the slow delivery. And short of taking government to court, really there's a problem. We're going to Parliament, which we're accountable to, we inform them year after year, and there seems to be no action. Maybe with the changes post-Vuyani, one might see better movement. But with the last 14 years where I've been, we've basically been knocking or banging our heads on the wall.
So are you saying you're washing your hands of it?
No, I'm not washing my hands. Now, having said so, and if you read the Karl Asmal's report on the review of constitutional bodies, we ourselves took a major hammering, and we are pleading as far as our slow pace in addressing child rights issues. And we had a commissioner who was responsible for child rights, and they left. Government took, up until now, since 2006, that vacancy has not been filled. And we've been crying that please provide us with a commissioner who will deal with child rights. So we have staff members who deal with child rights issues, but clearly one of the major failures of the Human Rights Commission has really been in advancing child rights. Now, of course, BMF can assist, and of course South Africans can assist. And this is a point I really want to make, and I'm not being very unfair. But at the end of the day, this country is not the Human Rights Commission's country. It's all our country. And therefore, what do we do as South Africans? One, to support constitutional bodies and to ensure that they do their work. When we're being hammered over Malema, we're so alone. I was saying to my friends in the NGOs, human rights, now what has happened to the human rights NGOs? When we're under attack and nobody even say, we're with you. We felt so alone, and maybe it's possible that when Vavi says, I regret, we're so happy and signed. Because otherwise, to continue the fight on our own was killing us. And therefore, I think it's very important that we also make sure that we do support these institutions and make sure they do their work. We appear before Parliament every year. I can assure you, when we appear before Parliament to account for ourselves, the media is not even there. NGOs are not even there. Nobody even cares about what we say in Parliament about the work we've been doing for a year. And therefore, there's a lot of ignorance amongst many black professionals about the work of the Human Rights Commission. If I also ask in this room, how many of you have been to our website or read our annual report? minus some people here, that will be the issue. So of course, like any other institution, we do have our failures and our successes, but I think our successes are far more than our failures. But certainly, the issue of child rights is one of our major failures which we're working on. Now, on the MDG, of course, goals. Of course, there are issues around the MDG goals and the weaknesses there. But I mean, for me, those are international issues where heads of states, as usual, after many, many failures, then come with this pledge. Okay, now in 2015, we're going to have school enrollment, blah, 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 blah. That's fine. As a public international lawyer, we still say charity begins at home. So for me, yes, we can engage in those debates at the international level about MDG and rights, lots and lots of books about those goals. But the issue is, MDG goals simply reflect on our own constitution. We are one of the few constitutions in this country, in this world, which have entrenched socioeconomic rights, which are judicially enforceable. Access to housing, water, food, and so forth. Now the issue is, what are we doing as a country to advance these rights? Of course, let academics worry about MDGs. But if we are told today that the gap between the rich and the poor is increasing, that 93% of the poor African people, and therefore no house, no water, and stuff like that, what are we doing about that? So we need to address that. Of course, we worry about the MDG, but as far as we are concerned as Human Rights Commission, we have a mandate to monitor socioeconomic rights, and we'll be releasing our report next year. We'll use MDGs as a point of reference, while at the same time addressing some of the weaknesses and challenges. We find it as a very useful standard going forward, because most governments do not want to provide information on what they've done around socioeconomic rights. There's also an element of speed doctoring. Yesterday I was keeping quiet when Joel was telling us about impressive enrollment in schools, where girl children are now even surpassing boys. That's good, but the other side is even worse. That yes, we are 60% of Africa's economy, we have a very high enrollment rate, but what about the quality of that education? South Africa now rates the lowest in Africa when it comes to math and science. We have one of the highest dropout rates. Only 2,000 matriculants, black matriculants in a year, get exemption to do science and math at high level. So yes, you can talk about enrollment, but the quality is also important. Our education system is actually in a serious crisis, even though we're the richest economy. So of course you can tell us about those figures and you fool the masses. But on the ground we know we're in a crisis. People are even saying now that our education system, as well as the health system, is even worse than under apartheid in the new government of South Africa. Thank you.
Chairperson, I just have one question for my brother. When are you coming to the bar?
Would that be the 19th hole?
When I retire from the Human Rights Commission, I'll come to the bar.
Okay, we're running out of time very quickly, but in the interest of democracy, if we just keep the questions very short, the three that I promised earlier, other question we're not going to be able to take. I think we'll have to exercise our networking abilities during lunch to do so. There's one that I received here from Langa, directed at Advocate Ngalwana, saying that with the arrival of the Chinese in South Africa, and I'm going to try and interpret and paraphrase, the arrival of the Chinese in South Africa, can you say that the judgment was steeped in and reflected in the progressive values of the Constitution? Has justice simply not become the prison of law? You can interpret that as you like. And one to you, Advocate Thipanyane, the farmer who shot the child, a black child, who then reportedly said that he thought the child to him it looked like an animal. What is your response to that? That's from school. And then just the final three questions that I identified earlier on, and then we need to wrap, unfortunately.
But my voice, yeah. Thank you. My name is Thipanyane. My question is directed to Advocate Ngalwana. I'm sorry I'm pronouncing Ngalwana. Yes. For us in the BMF, we have made a lot of noise in terms of employment equity. And I would like to find out from you, what is your take with regard to the Section 20, subsection 3 of the Equity Act with regard to the appointments of judges, seeing that you emphasize on the progressive values of the Constitution? I'm just worried the President might only be aware of the Equity Act. So if the President is not brought on board in terms of making a correct decision in terms of the coming appointments, what is the Johannesburg Bar going to do to actually assist the President in making a proper appointment?
All right, can we just give other people a chance as well? Maybe, should Jimmy take this one, the employment equity? Or will you be fine, Advocate Ngalwana? Please pass it on, the last two at the back. Thank you.
Thank you. My name is Wesi Koza. I would like to direct my question to Advocate Thipanyane. The question I have is, why has it been normalized that the media can purposely distort what our leaders say? Because we usually listen and we understand what they say, and they just willy-nilly, immediately after the person has spoken, distort the information.
Let's just take the final question for the session. Thanks. All right, is that everybody?
Okay, I start because I'm going to be very short. As regards the last question of employment equity, what the Johannesburg Bar is going to do to assist the President, I wish I knew. I don't sit on the Bar Council. The Bar, the decision that's made by the Bar is made by the Bar Council, theoretically on behalf of all members. But currently there is a split in the Bar because, you know, black practitioners don't really participate in the running and the decision-making processes of the Johannesburg Bar because of disagreements as regards governance and some issues, briefing patterns and so on. So we're still haggling, we're still fighting on those issues. But assuming that we did participate, we have an organization called Advocates for Transformation. We are the ones, and that is the organization that's pushing transformation at the bar and pushing that certain decisions go higher and to influence the President in making up the correct appointments. Now, the manner in which, in my view, the Bar Council would have to do that, I understand there is a committee. You know, there are subcommittees in the governance of the Bar. One of them is a parliamentary committee, and it is that committee that would sit and work out a plan or an action plan as regards what needs to be done in that regard. I personally, the only power I would have, if I can call it that, is to make what you've referred to as noises about employment equity in public platforms. I don't think, I don't know, maybe I'm underestimating my influence. I don't think I'll sit and draft a letter, send it to the President, that he would look at it and respond to it. I mean, practically speaking, I don't think that's feasible. As regards the question of the Chinese judgment, my friend here has insisted that he wants to deal with that issue. And so I will defer to him.
Thanks. The reason why I basically asked, and I hope Jimmy Mang is here, is because the Human Rights Commission had to mediate between the Minister of Labour and the Chinese after the pinky statements. And of course, the Minister said he was misquoted. So both parties shook hands, and then we left after 2 hours, by the way. And now, what came out, and I was at that meeting, what came out was that the problem, there were 2 problems. I personally, I was a little bit appalled that here came a judgment which even we were not even informed of as the Human Rights Commission to decide whether we should actually get involved or not. And I had colleagues from BMF saying they were going to appeal, blah, 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 blah. There was a lot of noise about the judgment. But when we got there, the Minister of Labour said, here's a problem. That in terms of the Population Registration Act, 1950 or something like that, which all of us had forgotten, the Chinese were classified as colours. And therefore, the court judgment simply had to endorse that in this country, Chinese are colours, and therefore they're beneficiaries of Employment Equity Act, which means in this country, Chinese are black. Now, so we either have to change the act. Now the issue is we must blame the lawyers in Justice Department as to why they did not review this act of 1950, an Apartheid Act, to address the situation. And as Jim was saying yesterday, well, maybe we need to be a bit careful though, and ensure that those Chinese who were classified as colours are Chinese who were in this country before 1994 and are citizens, and therefore there are not many. But at the same time, colleagues, in terms of the constitution of this country, we need to bear in mind that the first miners in this country were Chinese around 1890. They were brought here as indentured workers, exploited. It's only when they could not cope with the conditions of the mines, they passed the Paul Act of 1913 to force black people into the mines. Hence the Bambata Rebellion. Because nobody wants to work in the mines unless you are desperate. So then the Chinese were removed. So they stayed here. They were not white people. It was only in the late 80s when Chinese were declared as honorary whites. They also suffered discrimination, not at the same level as Africans. So when we talk about disadvantage, we need to bear that in mind. Of course now China is very powerful and they're very powerful. But what about those who are in this country who suffered? So how that decision is also implemented will require lots of wisdom from government, but we also need to ensure, as Ms. Jimmy was saying, that the 12,000 or 20,000 Chinese do not become a front for the billions of Chinese, because then that will actually undermine the essence of Employment Equity Act and affirmative action in this country. So BMF has to be very vigilant to ensure that there's no fronting by those who are now beneficiaries, but by those Chinese who are black today. Because, some of them are not black, others are black. And this is the funny part about this judgment. I'll leave it like that. Now, on the issues of farmers who should want black people, of course, there's a serious concern about the conditions in farming communities. Now, we basically regard black farm workers in this country as forgotten people. They are. They live very far from police stations. That's why we've had 2 public hearings on conditions in farming communities. Read the reports, it's appalling. Last week I was addressing South Africa. We said, listen guys, you better wake up. You cannot treat our people in the way that you're treating them. We received lots of stories. You remember in Kopis, a white farmer, after his farm workers resigned, exhumed their dead child who was buried, put the couple and the body in the van, drove it from Kopis to Pretoria. The couple went to the police station to lay a charge. Guess what happened? They were arrested by the police for carrying a dead body and sent back to Kopis. This year, this country, farming communities. I'll leave it like that. Now, on the distortions of the media, because our court has made a very clear ruling that media freedom is not a top right in our country. Dignity is also a top right. Therefore, media freedom cannot trump human dignity. And therefore, you cannot, in pursuance of freedom of expression, insult us and undermine our dignity as South Africans. Now, of course, a lot of people in the media say, no, media freedom is an absolute right. That is utter nonsense. Journalists in this country have to abide by the Constitution, and they have to respect the dignity of everyone. That's why when Mr. Bullard said whatever he said, we've got a complaint with him, and we're dealing with him. And if he does not satisfy us, we'll take him to court. We've got a complaint against Sapiro on the cartoons, and we're still deciding how we deal with that. Because we need to establish a standard in this country for the media as well, that as you do your work, please uphold human rights. Now, the Constitutional Court, unfortunately, tell us where the balance lies between media freedom and human dignity. So we still have to find an appropriate balance. Now, for example, I was saying to colleagues of mine, Mr. Jacob Zuma and the cartoons, the shower. Here is a man who apologized on the shower. Why is he continuously portrayed in the shower? He said, I'm sorry. Now, I was saying, if we were to follow that logic, can I therefore describe every time I write a cartoon about Mr. de Klerk, former apartheid champion? Would that be acceptable? Or former racist? The rape depends. Here is a man who was acquitted of rape. So when we show him with his pants, what are we seeing? Now, as for the other side, the blade and them, I won't say anything. Maybe they deserve the depiction. But the issue really is that we need to find an appropriate, as my brother was saying here, there are only three values in our country: dignity, equality, and freedom. And therefore it's important that comrades in the media also appreciate. I mean, we also get portrayed in a very bad manner. We don't say anything about that. But I mean, the fact is, and I said to my media friends, we need to be very careful that our own people do not rebel against journalists when they see them depicting their own people in a manner which goes against the spirit of Ubuntu. And we're not saying media freedom is not important. It's very important because they also need to expose corruption and the wrongdoings. But how we do it must be informed by our values: dignity, humanity, Ubuntu.
I'd like to thank our panelists, Mr. Mtunzi, and also Advocate Thipanyane, Advocate Ngalwana, and thank you so much for participating in this session. Just on the media issue as well, as much as we take ownership of everything else that surrounds our constitution, that is enshrined in our own constitution, we also need to be vigilant in terms of interrogating certain things that happen around us. Now, if a news story is deflammatory to anybody, it's more often than not, we don't find that the reverse happens when it comes to the media. So sometimes we reflect what it is that the story dictates that we do. I don't know if that makes sense. But let's just break bread and then we'll reconvene here, I think at about 1:15. At 1:30.
Yeah, before we leave, I think we must give Cindy a round of applause. Job well done. Thank you very much. I'm just going to make some few announcements because there are breakaway sessions before, after lunch rather. But I think I'd like to thank Advocate Thipanyane about, I think he strikes me as a guy who's quiet and I've never heard him being so vocal, but it shows the nature of the Black Management Forum. When people are here, they realize that they are free to express themselves. And by the way, these NGOs you're complaining about on human rights who never supported you, SPMF last year we said skill shortage is an urban legend. None of the black professionals supported us, actually. To the contrary, we were supported by NUM, which released a statement to support the BMF. And the Lord was correct when he raised the issue around NUM yesterday. I've contacted the Secretary General then. But I wanted to look at their memorandum that they submitted because we cannot just support everything. So we should say that we support clause this and that. That talks to what we're talking about. I'm still awaiting for Franz Panelists to send me that. But I think special thanks as well to Vuyani Ngalwana, is the friend of the Black Management Forum. He has been... If I like making a speech and making an example about you, Vuyani, I've never told you this, but he once told me a story. That one of the clauses in the Pension Fund Adjudication Act doesn't allow a pension fund adjudicator to go and defend himself or herself in court against the ruling that that the adjudicator would have made. And I always say that that's why we need revolutionary professionals like Ngalwana, but you also need a politicized bureaucrats that will change the act to enable the adjudicator to go to court and explain to the nation in terms of how he or she has arrived at that. So for transformation to be effected, to us, you epitomize what a professional, a revolutionary professional ought to act and behave like when we deal with these matters. And we thank you for the contribution. Yeah, finally there's a court case actually that we will be working on. I phoned Advocate Thipanyane's office to understand the procedures around Equality Court, and we have spoken to our lawyers. They've briefed the senior counsel. Am I allowed to name things? No? Okay, I'm not. Yeah, but the case around Envisage SA, which doesn't want to appoint black people in senior management, it's discriminating. We're going to take them to court. The matter is going through the legal processes. We'll make the announcement at an appropriate level. So, last thing actually I want to apologize on behalf of Jake Muloi, who didn't pitch, but I think it would have been a chaos if he was here from time point of view. By the way, we must wish him luck. He's going for an interview of these judges that you are referring to in Cape Town. Hopefully he will be the right type judge that can be appointed. I don't know the criteria. Yeah. So on housekeeping stories stuff, when we come back, there are breakaway sessions. If you're interested to attend employment equity session, come here in this room. Those who want to go to skills development is just behind the other side of the exhibition stands. Right at the opposite, there are opposite doors to these ones on the other side, on the very same floor. We'll make an announcement about the dinner actually when we come back. And after our plenary sessions, please come back here. We'll have just a high-level report, and then I think the president will have to close the conference officially. We'll make sure that it's short so that people will have enough time to go home and refresh and change and bring their best cloth for the dinner that will start 6:30 this evening. Thank you very much, ladies and gentlemen.